I'm Alex Grant, and this is the Law of the Case podcast for June 21st, 2024. Just a week after the high school graduation for the kids who survived the Sandy Hook Elementary School shooting, the U.S. Supreme Court issued a decision in Garland v. Cargill that struck down an ATF rule that banned bump stocks. A bump stock is what allowed a 64-year-old man to rain down automatic gunfire on people attending a music festival in Las Vegas in 2017. The result was 61 dead and over 400 people wounded. Hundreds more were hurt in the ensuing stampede. In the wake of that shooting, President Trump took executive action against bump stocks, rather than allowing Congress to amend the statute that already banned machine guns. That executive action spared many Republicans a tough vote. I'm Alex Grant, and I spent 23 years in the Department of Justice prosecuting nearly every type of case the department handles, including firearms and violent crime cases. And I am currently an adjunct faculty member with the Western New England University School of Law. In this episode, I will get into how the Supreme Court came to interpret a statute in a way that runs completely counter to the purpose of that statute. And I will talk about what it means for future gun control efforts and for how federal courts interpret statutes generally. I will try to go beyond the predictable ideological divide that had a publication like Slate mocking and excoriating the conservative six-person majority for allowing this common-sense gun control measure to fail. And on the other side, you had the National Review mocking Justice Sotomayor's dissent. That dissent was joined by Justices Kagan and Jackson, the predictable three-person liberal minority. The National Review called that dissent, quote, a train wreck of bad reasoning. Before we get to all the analysis, let's listen to a couple of recordings that show the frequency of the gunfire when a shooter places a bump stock on a semi-automatic rifle. The first clip is from the Las Vegas shooting itself. Next, I'm going to play the portion of a YouTube video done by Zach Nelson, someone who is familiar with shooting guns, but was trying out a bump stock for the first time.
So how a bump stock works is actually incredibly simple. The gun slides around inside of the stock and uses the recoil of the gun to shoot more bullets. My finger connects with the trigger, pulls it, and then the gun will bounce back and forth, and each time it hits my finger, it'll shoot another round. And since the gun is doing it all automatically, it can pull the trigger faster than I can pull the trigger. Hence the full auto function of the bump stock. This is my first time shooting with the bump stock, so we're going to see how it goes. I got the clip in place. The stock is functional. Safety is off. We're loaded. And let's see how this works. All right. Right.
Now, listening to these two clips, it is hard to fault Justice Sotomayor when she uses the looks like a duck, quacks like a duck analogy to say that a semi-automatic rifle equipped with a bump stock looks and acts like a machine gun, and therefore is a machine gun. Now, the National Firearms Act of 1934 effectively outlawed machine guns, and machine guns are defined as, quote, any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The definition also includes any part designed and intended for use in converting a weapon into a machine gun. Now, the question is whether the ATF rule which banned bump stocks, went beyond the authority the statute conferred. The ATF can they can enforce the statute, but it can't go beyond the statute. Now, first of all, the statute's definition is meant to be broad, and it includes parts that allow a weapon to be converted into a machine gun. So at first blush, that would seem to sweep in the bump stock. However, the whole case turns on one phrase that you just heard: a single function of the trigger. A machine gun shoots more than one shot, quote, by a single function of the trigger. I listened to the oral arguments when the case was argued a few months ago, and the lawyers and the justices spent an hour and a half talking about how guns work: machine guns, semi-automatic rifles. There was a discussion about the hammer and the trigger and what the bump stock does and does not do, and they did it in minute detail. I found it pretty tedious at the time, and if you read the majority and dissenting opinions, it's a lot more of the same. Justice Thomas's majority opinion included several illustrations of parts of a gun, including a GIF. But you can break it down pretty quickly into a disagreement about whether the phrase function of the trigger refers to what is happening mechanically within the gun or the action the shooter is taking on the gun. I thought the two lawyers who argued the case did a great job of distilling the issue in their very first words before the justices. Let's listen first to the attorney for the Solicitor General's office, where he argued to uphold the bump stock ban.
Fire a rifle fitted with a bump stock. The shooter simply places his trigger finger on the built-in finger ledge and uses his other hand to press the front of the rifle forward. As long as the shooter maintains that steady forward pressure, the rifle will fire continuously until it runs out of bullets. And it will empty a 100-round magazine, like the ones used in the Las Vegas shooting, in about 10 seconds. Those weapons do exactly what Congress meant to prohibit when it enacted the prohibition on machine guns, and those weapons are machine guns because they satisfy both disputed parts of the statutory definition. First, a rifle with a bump stock fires more than one shot by a single function of the trigger. In common usage today, as in 1934, a function of the trigger happens when some act by the shooter, usually a pull, starts a firing sequence. With a semi-automatic rifle, it fires one shot for each function of the trigger because the shooter has to manually pull and release the trigger for every shot. But a bump stock eliminates those manual movements and allows the shooter to fire many shots with one act, a forward push. Now, respondent says that a separate function of the trigger happens every time the trigger on a traditional rifle moves backwards and releases the hammer, even if it moves without any further manipulation by the shooter.
So the government is saying that because the shooter with a bump stock does not have to keep pulling the trigger to fire each bullet, like you would have to do with a semi-automatic rifle, there is a single function of the trigger. And the rifle becomes automatic and is therefore a machine gun with the bump stock. So with the bump stock, the shooter maintains that forward pressure and the bullets keep pouring out, much like a shooter with an M16 automatic rifle does when he keeps the backward pressure on the trigger and the bullets keep pouring out of the M16. But the other point that the government attorney is making is that a rifle equipped with a bump stock is doing exactly the thing that Congress wanted to prevent. But let's listen to how the lawyer for Cargill is the person who is challenging the bump stock ban, puts it.
The statutory definition of machine gun extends only to weapons that fire more than one shot automatically by a single function of the trigger. A bump stock equipped rifle can fire only one shot per function of the trigger because the trigger must reset after every shot and must function again before another shot can be fired. The trigger is the device that initiates the firing of the weapon, and the function of the trigger is what that triggering device must do to cause the weapon to fire. The phrase function of the trigger can refer only to the trigger's function. It has nothing to do with the shooter or what the shooter does to the trigger.
So that's a very technical argument about what is happening inside the gun. And he is saying that the phrase, a single function of the trigger, can only be understood that way. And actually what he is saying is correct as a factual matter. The trigger is going back and forth during bump firing, and it's doing so rapidly. The shooter's finger is in that stationary position with the bump stock, and it is the combination of the forward pressure exerted by the shooter and the backward recoil that allows the trigger to reset so rapidly that the semi-automatic rifle with the bump stock is shooting approximately as fast as the traditional machine gun. But isn't that exactly what Congress was trying to prevent? A rifle shooting just like a machine gun? Now, Justice Thomas, who ends up writing the majority opinion striking down the bump stock ban, actually asks that question. Justice Thomas noted that Congress passed this statute in 1934, just after the Prohibition, which brought us Al Capone and gangland shootings using Tommy guns and other machine guns. And as Justice Thomas put it, significant damage from machine guns, carnage, and people dying. So he asks, and I'm quoting here from the transcript, so with that background, why shouldn't we look at a broader definition of function, one suggested by the government, as opposed to just the narrow function that you suggest? And here's what Cargill's lawyer said in response.
So if the court is going to interpret the statute based on what it says, rather than based on the purposes or perhaps the overarching goals of what the 1934 legislature might have been, there's no way it could accept the government's construction of the statute because it is changing the enacted words.
So Cargill's lawyer is being quite transparent. He is saying, ignore the statutory purpose and focus only on the words, single function of the trigger. And ultimately, Justice Thomas's majority opinion does exactly that. And here's how Justice Sotomayor's dissent describes the majority's approach. Quote, the majority looks to the internal mechanism that initiates fire, rather than the human act of the shooter's initial pull, to hold that a single function of the trigger means a reset of the trigger mechanism. She goes on to say, today, the court puts bump stocks back in civilian hands. To do so, it casts aside Congress's definition of machine gun and seizes upon one that is inconsistent with the original meaning of the statutory text and unsupported by context or purpose, end quote. Now, Justice Alito, who was part of that 6-member majority, wrote in a concurring opinion that the court basically had no choice but to strike down the bump stock ban. It had to invalidate that rule. And here's what he said. There can be little doubt that the Congress that enacted this statute would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the statutory text is clear, and we must follow it. So this is a great argument or debate about how you are supposed to interpret statutes. And what I would say is that the majority opinion is what I would call extreme textualism. So let me linger on that term, textualism. This is the idea that judges, when they're interpreting statutes, focus on the words of the statute above all else. And it gained force probably in the mid-1980s when Justice Scalia joined the court. He was a big proponent of textualism. He was a big proponent of originalism, which I'll talk about in just a sec. And his idea was that looking at what Congress must have meant or probably meant was not the right way to go about it. And that had to do with statutes, and it had to do with the Constitution itself, that what the judges were doing was merely interpreting words, and they needed to focus on those words and let that analysis of the words lead to whatever result it leads to. Now, I call this majority opinion extreme textualism because the interpretation that they arrive at is so antithetical to, opposite to, what Congress clearly intended. Now, you would think that the words of Congress and what Congress intended would go hand in hand. But sometimes it's not that clear. And sometimes Congress's intent or purpose is not that unclear. But in this case, even Justice Alito, who's part of the 6-member majority, gives the game away. He says, yes, Congress surely did mean to prevent devices like bump stocks, but it doesn't matter. So why does textualism have such a hold on 6 members of the court if it doesn't seem to comport with what Congress wanted, and it's likely to have harmful effects on society? I mean, what's to be said for it? Well, Justice Scalia and his adherents over the years latched on to textualism as a means of limiting judicial discretion, to eliminate judicial activism. So rather than an open-ended inquiry about what Congress might have meant, which could quickly morph into, well, what do I, as the judge, think Congress should have meant? We're just going to limit that discretion by confining the analysis to the words. Now, originalism is kind of an offshoot of textualism, at least to my mind, because it's a focus on the words and more particularly on the original meaning of the words. What did the words mean when the statute was enacted? And that's another way of cabining discretion, of limiting judicial activism. At least that's how the 6-member majority, I think, would see it. Now, the 3 dissenters in this case, even though they look at statutory purpose and they use that to bolster their argument that the statute should be interpreted to ban bump stocks, these 3 liberal judges also pay homage to textualism. They claim, as Justice Sotomayor did, that they're the ones that are adhering to the words. They're the ones that are adhering to the actual text passed by Congress. I think at one point, this was a few years ago, Justice Kagan said, "We're all textualists now." So there is this consensus on the 9-member court that you need to focus on the words first and foremost. Now, my take on this is that this is an extreme case of textualism because the textual argument advanced by Cargill's lawyer, that a single function of the trigger has to mean what is happening mechanistically within the gun and not what the shooter is doing to the gun. That argument, I don't think it was inevitable. I don't think it's inescapable, as Justice Alito said. Justice Sotomayor makes a very plausible and I would say a powerful argument on the text of the statute allowing for bump stocks to be included within this definition of machine gun. So what I see is 2, at least plausible textual arguments, 2 plausible arguments about what the words mean. One that effectuates the statute's purpose, and one that is completely opposite to the statute's purpose. And yet we are left with the interpretation that is defeating the statute's purpose, which is that Congress did not want weapons that allowed you to rain bullets down on people like what happened in Las Vegas. They thought that society would be better off if we didn't have that if we didn't have Tommy guns, if we didn't have criminals able to inflict mass carnage with machine guns. That was their purpose. And striking down the bump stock ban really defeats that purpose. So I would have come out the other way. Now, what I find also interesting about this use of textualism to reach the result that is so contrary to Congress's purpose is that the judges who did so, the conservative majority, these are also the folks that have propounded this major questions doctrine that you saw in the student loan case. You saw that in the EPA case a couple of years ago, where the EPA was trying to regulate greenhouse gases. And the Supreme Court decided that the EPA did not have the authority from Congress to do that because the statutory text did not clearly allow for it. And this major questions doctrine said that if you are going to regulate something in a way that is going to have a major impact on the country, major economic impacts, then Congress needs to speak very clearly. So in the student loan case and in the EPA case, you had statutory texts that could plausibly be read to support the regulation. What was more in question in those cases was, well, is that really what Congress intended? So what the conservative majority in those cases did was to honor, in a way, Congress's purpose. They asked the question in the student loan case, well, when Congress passed this HEROES Act, did it really intend to wipe out over $400 billion worth of student debt? I mean, did Congress really intend to have such a profound effect on the government's finances and on the economy in general? And in the EPA case, did Congress really intend to allow the EPA to fundamentally change our relationship with oil and gas and energy in general? And in the respect that they gave to congressional intent and purpose, the conservatives put the brakes on regulations. Here, they put the brakes on regulations where they're defeating Congress's purpose. And that's what I find interesting, is that in one set of cases, they're trying to effectuate congressional purpose, at least as they saw it. And here, they're admittedly defeating congressional purpose. Now, Justice Alito and the rest of the majority opinion say that it simply puts the issue back on the plate of Congress, that Congress is free to amend the statute as they were considering doing in the wake of the Las Vegas shooting, basically to allow Congress to do their job. Now, practically, politically, there are few people who believe that Congress, at least in this session, is going to pass a bump stock ban. We are in such a polarized, ideologically divided environment that getting any kind of legislation passed, let alone anything that has to do with guns, it just seems like it's impossible. But theoretically, the statute can be amended. So this does not have the same effect as the gun control decisions that the Supreme Court made under the Second Amendment, which I find to be particularly problematic because it cuts out Congress. These decisions cut out state legislatures. They cut out the voters in deciding what kind of relationship we want to have with guns in society. The decisions in Heller and Bruin struck down regulations that had been in effect for decades as different cities and states were trying to cope with gun violence. And when the Supreme Court decides something under the Second Amendment, as opposed to interpreting a statute like it did here, the repercussions are much greater because essentially the Supreme Court is drawing lines on what kind of public policy over gun control is even permissible. Even though this outcome can be fixed legislatively, the liberal minority in this case, the dissent, sharply protested the decision. The protests from the dissenting judges are so strong, I think, because they realize that Congress isn't really going to do anything, or at least they're not going to do anything anytime soon. And that's what makes these statutory interpretation cases so high stakes, so monumental, because they could be the last word on bump stocks, or in the case of student loan debt, or in the case of the EPA and greenhouse gases, the last word, at least for some significant amount of time. If this was just a case of the Supreme Court interpreting a statute and sending it back to Congress with the expectation that Congress would, in regular order, address the issue and fix it in one way or the other, these cases, like the one in Garland v. Cargill, would seem relatively unimportant, and they would be an indication that the usual legislative process, democracy in action, is working. Unfortunately, these contested issues, like the EPA greenhouse gas case, the student loan case, the bump stock case here, the key decision makers, unfortunately, become the Supreme Court justices, who have actually a limited role, which is to interpret statutes that have already been passed. And they are doing so by looking very narrowly at words and coming up with constructions that may or may not be the only constructions. And in fact, I would say that in each of these cases that I've talked about, there were very plausible arguments on the other side. And when the Supreme Court is not looking at statutory purpose, like it failed to do here, the result is that the intent of Congress from 1934 is not effectuated, and the intent of Congress today is not effectuated at all, because it simply does not take up the issue. That is, until the next time there's a mass shooting with a person using a bump stock to rain bullets down in rapid fashion, like we heard earlier in the show. And at that point, there will be thoughts and prayers extended to the victims, and the silence we have heard in the wake of the Supreme Court's decision will be replaced by calls for action. And at that moment, there will be a chance to amend the machine gun statute to ban bump stocks and to prevent shooters from spraying rounds on unsuspecting civilians. Until next time, I'm Alex Grant with the Law of the Case podcast. You can find us on Twitter and on Facebook, most podcast apps, and you can email the show, lawofthecase@gmail.com.